This courtroom moment starts like many others, but within seconds, it becomes something far more intense. A defendant walks in fully confident, believing the rules don't apply to her, convinced that clever words and bold defiance can overpower the law itself. She speaks with certainty, challenges authority, and refuses to back down, expecting the court to bend to her version of reality. But the judge isn't here for theatrics. As the hearing unfolds, patience begins to wear thin. Every argument rooted in false beliefs is calmly dismantled, piece by piece. The judge listens, warns, and explains, yet the defendant keeps pushing, crossing lines that should never be crossed in a courtroom. What she thought was confidence quickly turns into confrontation. Then comes the moment everything changes. With firm authority and zero hesitation, the judge delivers a blunt reality check. No loopholes. No special status. No immunity. Just the law, clear, direct, and unavoidable. The shift in the room is instant. The confidence fades, the tone changes, and shock replaces arrogance as the defendant realizes this isn't a game she can talk her way out of. This video is more than a heated exchange, it's a powerful reminder of what happens when ideology collides with reality. Watch closely as a courtroom turns into a lesson about consequences, accountability, and the limits of defiance when faced with real authority.
Answer my questions, please, ma'am. I'm just trying to understand. Okay.
For the record, I recognize Ms. Pugh. She's been here before.
I do as well, for the record.
And I looked into Mr. Christopher Wiley. I can't find that person as a practicing lawyer in the state bar page, and I have not been contacted by anybody on Ms. Pugh's behalf.
All right, so Ms. Pugh, Mr. Lewis has been appointed to represent you at this point. Obviously, you know as well as anyone that you're in custody and we want to get your case taken care of. If you've hired or your family has hired another lawyer, then they have to contact the court so that we can do something with your case. And do you know if they've hired someone?
Respectfully, Your Honor, I do not agree with your appointed foreign agents, considering that the first duty is to the state and will be considered conflict of interest. You know.
Okay, so if you don't want, the only thing I can do, I'm appointing an attorney to you to help you, right? So if you don't want a court-appointed attorney, then your only option, two things. One is to represent yourself or to hire a lawyer. So if you don't like the way it works, then you do something different. So are you, listen to what I'm saying. Are you either going to represent yourself, or are you going to let Mr. Lewis represent you, or are you going to hire someone?
Objection, Your Honor. Respectfully, is this a court of record?
It is a court of record. So your objection's overruled.
Okay. Respectfully, Your Honor, where is the verified claim that is being placed against my trust?
It's right here. It's called an indictment. And Mr. Lewis has a copy of it, and he can show it to you. So that would be the verified claim against you.
Okay. Your Honor, respectfully, Your Honor, there were writs that was filed to the case that still haven't been received.
I've received your petition for writ of habeas corpus, and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claim and not being given the proper opportunity to obtain proper counsel to effective defense.
It's overruled.
Okay.
You're running out, aren't you?
No, it's fine.
Thing, Miss Pugh. I appreciate your position, but listen, Miss Pugh, don't speak over me.
Respectfully, for my incarceration.
Miss Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen to me. Everything you have there is overruled. And here's one of the reasons why, is because you have a lawyer. And your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful. So I'm going to leave Mr. Lewis as your attorney unless you choose to represent yourself or hire someone else. I'm going to give you 2 weeks to determine what you're going to do. You can go back. You can go back with the bailiff.
I do not agree or comply to your appointed
Go back.
agents.
You already said that, and that's overruled.
Is to the state.
Go back with the bailiff. Get your own attorney or represent yourself if you don't like it. Ms. Pugh, Mr. Jeffries has been appointed to represent you. He's just been given, he's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of your appointed court agents, considering that their first duty is to the state.
I understand. We've had this conversation before.
Confidential. And for the record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me. If you want to represent yourself, then there is a process that we have to go through, and we'll do that today. If that's what you want to do, we'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you are expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of things couple of options, and we'll go over those as well. Okay. So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you?
I know they've been accused of.
Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I don't understand, Your Honor.
So here's the thing. If you want to represent yourself by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I've never did anything wrong.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine, after they listen to the evidence, if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff. Go back with the bailiff. Welcome to the criminal appointment list.
Yeah, fun, Judge.
This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, get ready like you would. Probably it's going to go straight onto a jury.
Right, I would
And
assume.
we'll just get it figured out that way.
The moment the defendant enters the courtroom, there's an unmistakable air of defiance around her. It's not nervousness or fear that she carries, it's certainty. The kind of certainty that comes from believing you've discovered a hidden truth that everyone else is blind to. She stands as though the outcome is already decided in her favor, not because of evidence or law, but because of belief. She begins speaking almost immediately, her words flowing fast and confidently. She challenges the court's authority, questions its legitimacy, and insists that she does not recognize its power over her life. Every sentence sounds rehearsed, as if she's practiced this confrontation countless times in her head. To her, this isn't a courtroom, it's a battlefield of ideas, and she believes she's armed with the ultimate weapon, refusal. The judge listens. There is a calm presence behind the bench, a stillness that contrasts sharply with the defendant's restless energy. The judge allows her to continue, giving her space to speak freely. There's no rush to shut her down, no immediate correction. This patience only fuels the defendant further. She mistakes silence for uncertainty and continues pressing forward. Her arguments grow more elaborate. She speaks about consent, about personal sovereignty, about how authority only exists if she agrees to it. She dismisses legal procedures as meaningless rituals, insisting that words and declarations alone can free her from responsibility. Her voice carries confidence, but beneath it lies something fragile, a fear of losing control. The courtroom remains steady, unmoved. When the judge finally responds, the tone is measured and precise. There is no emotional reaction, no visible irritation. The judge explains, slowly and clearly, how the court functions, why it has authority, and what the defendant is actually facing. The explanation is grounded, factual, and calm, everything the defendant's argument is not. But she refuses to absorb it. Instead, she repeats herself, as if repetition might turn belief into reality. She talks over the judge, interrupts explanations, and dismisses corrections. Her confidence begins to sound strained now, louder and sharper, like someone trying to convince not just the court, but herself. The tension in the room builds quietly. The judge reminds her that this is not a discussion or a debate. This is a legal proceeding. Rules apply here. Order matters here. Authority exists here. These words are not spoken with anger, but with certainty, the kind that does not need to be enforced through volume. Still, the defendant resists. Her posture stiffens. Her tone becomes defensive. She accuses the court of bias, of injustice, of misunderstanding her position. She clings to the idea that if she can just say the right phrase, assert the right claim, reality will bend. But reality doesn't bend. The judge begins to address the consequences. Not as a threat, but as a fact. The court explains what will happen if the defendant continues to disrupt proceedings, if she continues to refuse lawful instructions. The words are clear, direct, and unavoidable. The courtroom grows quiet, not because anyone has been silenced, but because the weight of those words lands heavily. For the first time, the defendant hesitates. It's subtle. A pause. A shift in posture. A brief flicker of uncertainty crossing her face. The certainty she carried in begins to crack. She responds more slowly now, choosing her words carefully, as if sensing that the ground beneath her is no longer solid. The judge continues, dismantling the remaining misconceptions piece by piece. The court explains that personal beliefs do not override legal obligations. That refusing to acknowledge authority does not remove it. That consequences exist, regardless of agreement. These truths are delivered calmly, almost gently, but they hit harder than any raised voice ever could. The defendant listens now, not because she agrees, but because she has no other option. Her earlier confidence has drained away, replaced by tension and discomfort. The realization is setting in that the situation is real, immediate, and beyond her control. The courtroom is no longer a stage for ideology, it is a place where outcomes are decided. As the exchange continues, the transformation becomes undeniable. The person who entered believing she was untouchable now stands face to face with accountability. Her arguments grow shorter. Her interruptions fade. The fight that once fueled her words begins to burn out. The judge remains steady throughout. There is no celebration, no satisfaction taken in the defendant's realization. The court simply continues doing what it exists to do, apply the law fairly, consistently, and without emotion. The system does not argue. It does not persuade. It does not negotiate with belief. It enforces reality. By the time the moment reaches its peak, the lesson is unmistakable. Confidence without understanding leads to collapse. Defiance without foundation leads to consequence. And belief, no matter how strong, cannot erase responsibility. The courtroom does not need drama to make its point. The silence does that on its own. The defendant stands there, no longer defiant, no longer in control, forced to confront a truth she tried desperately to deny, that the law does not require permission, acknowledgement, or belief to exist. It simply does. And in that realization, everything changes.